Today's quick tip, we're going to talk about direct liability for business associates. Since 2013, covered entities have been struggling with new provision requirements for business associate agreements and cooperation from business associates as required by law. Business associates, please note that OCR has authority to take enforcement action against business associates only for those requirements and prohibitions of the HIPAA rules that appear on the list provided in the fact sheet that we're going to go over today. There are 10 specific items listed on the OCR website and in the fact sheet, and we're going to go over the first 5 right now. Failure to provide the Secretary with records and compliance reports, cooperate with complaint investigations and compliance reviews, and permit access by the Secretary to information, including protected health information, pertinent to determining compliance. Taking any retaliatory action against any individual or other person for filing a HIPAA complaint, participating in an investigation or other enforcement process, or opposing an act or practice that is unlawful under the HIPAA rules. Next, we have failure to comply with the requirements of the security rule, and failure to provide brief notification to a covered entity or other business associate. And next, we have impermissible uses of disclosures of PHI. Next, we have failure to disclose a copy of electronic PHI to either the covered entity or the individual or individual's designee to satisfy a covered entity's obligation regarding the form and format and the time and manner of access under the HIPAA rules. Failure to make reasonable efforts to abide by the minimum necessary rule and limit release of PHI to accomplish the intended purpose of the use, disclosure, or request. And lastly, which are failure to perform the following: failure to provide an accounting of disclosures, failure to enter into business associate agreements with subcontractors that create or receive PHI on their behalf, and failure to comply with the implementation specifications for such agreements. And lastly, failure to take reasonable steps to address a material breach or violation of the subcontractor's business associate agreement. Covered entities and business associates alike should ensure that there is a written, compliant agreement in place which reflects current HIPAA rules related to the special relationship between a healthcare covered entity and the business associate. I highly recommend you review the entire fact sheet posted on the government's website, or you can access the information easily through a Google search. Thank you for joining me today for this HIPAA compliance tip. Consider additional professional training through the American Institute of Healthcare Compliance. We offer annual staff training, release of information training, and comprehensive privacy and security compliance officer programs. Visit our website for more information or call us. We'd love to hear from you.